We'll hear argument first this morning in Case 08-1521 McDonald v. City of Chicago. In this case, several suits were filed against Chicago and Oak Park in Illinois challenging their gun bans after the Supreme Court issued its opinion in District of Columbia v. Heller. In that case, the Supreme Court held that a District of Columbia handgun ban violated the Second Amendment. There, the court reasoned that the law in question was enacted under the authority of the federal government, and thus, the Second Amendment was applicable. Here, plaintiffs argued that the Second Amendment should also apply to the states. Justice Alito, I'm trying to talk. Stop it. Oh, stop it. Mr. Gura, take it away.
Mr. Chief Justice, and may it please the Court. Although Chicago's ordinances cannot survive the faithful application of due process doctrines, there is an even simpler, more essential reason for reversing the lower court's judgment. The Constitution's plain text, as understood by the people that ratified it, mandates this result. In 1868, our nation made a promise to the McDonald family. They and their descendants would henceforth be American citizens, and with American citizenship came the guarantee enshrined in our Constitution that no state could make or enforce any law which shall abridge the privileges or immunities of American citizenship. The rights so guaranteed were not trivial. The Civil War was not fought because states were attacking people on the high seas or blocking access to the Bureau of Engraving and Printing.
This argument is contrary to the slaughterhouse cases, which have been the law for 140 years. It might be simpler, but it's a heavy burden for you to carry to suggest that we ought to overrule that decision.
The slaughterhouse cases should not have any stare decisis effect before the court.
The Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller. I think that the Privileges or Immunities Clause was the more appropriate avenue for rights incorporation. I reject Justice Thomas's separate claim that the Privileges or Immunities Clause of the 14th Amendment more appropriately incorporates the Second Amendment against the states. The court's decision in the slaughterhouse cases rejecting the use of the Privileges or Immunities Clause for the purpose of incorporation was long since decided, and the appropriate avenue for incorporating rights was through the Due Process Clause. I agree with Justice Alito's opinion. Rights that are fundamental to the nation's scheme of ordered liberty, or that are deeply rooted in this nation's history and tradition, are appropriately applied to the states through the 14th Amendment.
I agree with Alito. The Second Amendment should be incorporated to the states. I believe in regulations, however, people should be able to defend themselves with their personally owned guns.
Section 1 of the 14th Amendment decrees that no state shall deprive any person of life, liberty, or property without due process of law. The first and most basic principle established by our cases is that the rights protected by the Due Process Clause are not merely procedural in nature. Procedural guarantees are hollow unless linked to substantive interests, and no amount of process can legitimize some deprivations. I have yet to see a persuasive argument that the framers of the 14th Amendment thought otherwise. Although impressively argued, the majority's decision to overturn more than a century of Supreme Court precedent and to unsettle a much longer tradition of state practice is not, in my judgment, built upon respect for the teachings of our history, solid recognition of the basic values that underlie our society, and wise appreciation of the great roles that the doctrines of federalism and separation of powers have played in establishing and preserving American freedoms.
I agree with Alito's opinion and have written a separate concurrence in response to Justice Stevens' opposing views. The points Stevens brings forward are not solving the problem, but instead complicating the situation by bringing up unnecessary questions. Leaving the right to bear arms unincorporated to the states, as he suggests, would be a threat to democracy. The right to bear arms is deeply rooted in America's history and tradition and must stay that way. I do not believe we should reinstate the Privileges and Immunities Clause, but should instead incorporate the Second Amendment through the Due Process Clause.
Justice Stevens has written a dissenting opinion, which I agree with. In addition, I have also written a dissenting opinion. Militias, at the time the Constitution was written, as well as today, should be the only citizens with the right to bear arms. The Second Amendment shouldn't permit average citizens, such as store clerks, given protection to shoot burglars, to own a gun for said personal uses. The outlawing of guns in the city of Chicago saved hundreds of lives, proven by multiple accounts, such as the lowering of the crime rate and the decrease of shooting incidents. It seems as if throughout time guns have been favored over life, but with other amendments we've always seen life outruling the law. This type of ruling is an unjust bias.
I agree with Breyer. Incorporating the Second Amendment to the states for personal protection was not the framers' intention.
I join with Justice Ginsburg in supporting Breyer's dissent against applying the Second Amendment to the states. The Due Process Clause states that there are some rights so fundamental that they must be incorporated to the states, such as free speech and freedom of religion. Other rights, including the right to self-defense, are fundamental, but not so much that they require incorporation through the 14th Amendment.